ladies and gentlemen, we are back for episode 3 with my top G, Lacey G.
Thank you so much, Mark Lassiter. What are we talking about today?
Well, in the last episode, we talked about what you should do and what to expect once you're arrested and how to hire an attorney. So today, I want to flip it around and say, if you are the attorney, what should you be doing? What should you be informing your client about in that initial consultation? What should you be looking for? What things should you concentrate on? And we'll kind of take it from there. Because in the initial consultation where the client decides who to hire, that should be it. They shouldn't have to worry about anything else because you, the client, are paying me, the lawyer, the money to do the job.
To stress out is what you said earlier.
That's
to take
right.
on the anxiety.
You're paying me to have the ulcer, right?
Mm-hmm.
So now, as the attorney, what should you be doing, right? Because this is not just a show for individuals who have been charged with an offense. This is also a show for lawyers to see, what should I do? Should we listen to the guy who for 20 years has won some of the hardest cases out there? And how did you win? And what did you do? And what worked for you? So we're going to teach you, the attorneys, along with educating you, the citizens.
Okay.
All right. So starting out, let's say you come to me. So I want you to make up a factual situation about getting pulled over for DWI. Anything you want, you make it up. You're sitting in front of me and I say, okay, Lacey, my name's Mark Lassiter. We've talked on the phone. Tell me a little bit about what happened. So the first thing an attorney should ask is what happened, because he can't really give you any advice if he doesn't know. Now, sometimes my clients in DWIs particularly go, we can't remember anything. And I go, okay, and I jump straight to the process. But for this example, Lacey, give me a fact pattern. Hypothetical fact pattern. You're in my office. I say, Lacey, tell me what happened.
I got off from a long day, went to a happy hour. I had a couple of glasses of wine.
So let me stop you right there. And this is what I would do in a meeting. So tell me, Lacey, when did you leave work? What time?
5:30.
5:30.
PM.
Okay. And there are witnesses that could attest that at that point in time, you'd had nothing to drink, right?
Yes.
Now that's going to become important later, but I, as the attorney, am now gathering factual information from what she's saying that will assist me in defending the case. So I can establish with witnesses at 5:30, she is not intoxicated, has had nothing to drink. That will matter later on. Okay, continue.
I met some friends at a nice wine bar. Insert your wine bar here if you would like to be a sponsor of the Lassiter Law podcast. Met my friends out at a nice wine bar, had 3 glasses of red wine and a little bit of cocaine.
Okay. And during the time that you were with your friends, you said you had 3 glasses. About how long of a period of time was that?
2 hours.
So over 2 hours, you have 3 glasses of wine. Standard pour?
The bigger pour. They offered a bigger pour.
They offered a bigger pour. So 3 glasses is really probably closer to 5. All right. Now you have the cocaine, but it's important to note, and an attorney should know his drugs, is that cocaine is a stimulant, right? Whereas alcohol is a depressant, right? So what happens is it's almost like offsetting. That's why when you do cocaine or you do speed or you do Adderall, like you're up all night, right? Because it's keeping you going. You're actually super focused. But anyway, all right, continue. So after that, you're with your friends. Do they have the same amount to drink? You're laughing.
I was trying to throw you off with the cocaine. Now I'm thinking, well, man, next time I go drinking, I'm going to have some cocaine with me to cancel it out.
So now we have the advice. If you drink, if you get a depressant, make sure you have an upper and a downer, ladies and gentlemen, to offset. Yeah, that's not what we're saying, but okay. There's just something else to deal with.
Yes, my friends had about the same amount.
About the same?
Mm-hmm.
Okay. So keep going. So what point did you decide to leave? So that's over 2 hours.
We had an appetizer, and then I was going to leave to go get some more cocaine.
Great. So you're on your way to your dealer.
Yes.
And what happens?
They said I was swerving.
Okay. So you get pulled over for swerving. When you get pulled over for swerving, and usually I'll jump in at this point. All right. When the officer pulled you over, Did he state that the only reason he was or did he say the reason I'm pulling you over is X, in this case, swerving?
I asked him why I was being pulled over, and he said because I swerved.
Okay, ladies and gentlemen, important aspect here. So one of the things, if you can remember it, because we've gone over this in episode
I
one,
had
what to
enough
do,
cocaine.
what to do if you've been pulled over for a DWI. You typically want to do nothing because you can't remember what you're supposed to do. But if you can remember, a very important thing to do would be to ask questions, because when you ask questions, you are being recorded on the officer's body cam, and the answers that he gives, we can hold him to. So Lacey, in this case, Top G, very smart, said, "Why are you pulling me over? What did I do wrong?" And his answer was,
I saw you swerve.
okay. Now, also important, ladies and gentlemen, don't fight the officer. He's given you an answer. You don't have to say, I didn't swerve, because at that point in time, it doesn't matter, because he's never going to believe you because he's telling you he did something. Now, I've had instances where the officer says you were speeding. And if you did not speed, or if you ran a red light and you didn't run a red light, it is perfectly fine to say, no, I didn't. You're wrong. But that's it. Don't go any further, because there's no point in getting into an argument. So if you didn't swerve and you felt that way, you could say, I don't believe that I did. Okay. But keep in mind, he's got an in-car system that's going to capture it if it's there. Mm-hmm. Okay. But continue on. So he stops you from swerving. Did he ask you how much you'd had to drink?
Yes.
And what did you tell him?
Just a little bit.
Just a little bit. Keep in mind, this is a hypothetical, ladies and gentlemen. I am giving you what I would do in an actual meeting. So lawyers, take note, because these things that I am asking matter. They are the way in which you will defend the case, but you cannot defend the case appropriately without developing a strategy, and you cannot develop a strategy without knowing the facts. So we're going to continue on. So I said, my last question to you was,
how much did you
have to drink?
And I said, just a little bit.
Just a little bit. Did the officer ever ask you to specify how many drinks you had? Many times the officer doesn't.
No.
So now I'm writing down, I know the officer does not know the amount of alcohol. Now I ask the next question. Did he ever ask you when your last drink was?
He did not.
And I write down, no idea, last drink. Now, why that matters is something called retrograde extrapolation. In retrograde extrapolation, experts attempt to deduce what your blood alcohol score would have been at the time of driving. Because when you get a blood alcohol or a breath alcohol score, all of these things are at the time of the testing. Well, that doesn't help a jury. They need to know what you are at the time of driving, because you could be lower at the time of driving than at the time of testing. You could be the same or you could be higher. Many times, the state tries to establish through retrograde extrapolation that you were higher at the time of driving because your blood alcohol content goes down. Now, when you have blood alcohol content, lawyers should be able to explain this to your clients. It is not like a bell curve. You don't go up to a peak and then start going down at the same rate. It can go up very sharply. It can go up very slowly, depending on a person's characteristics. And then it plateaus for a while. Then it gradually goes down. So it is not the curve that you would think of, that most people think of with alcohol. Mm-hmm. So I'm getting the answers to the questions so that if the officer does not get the last known time of drinking, then they cannot do retrograde extrapolation. Whereas you, the citizen, which is why I say don't answer any questions, if you tell an officer, my last drink was at 9:00 and it's midnight, well, by any scientific characteristic or measurement, you're going to be going down at the time of testing, because the test is probably going to be another 1 to 2 hours. So there's 5 hours of non-drinking, according to you, the citizen. Don't give them that answer. Just say, with all due respect, I don't know what the law is. I'd like to talk to a lawyer. I'd like to call Mark Lassiter. He's going to tell you no. And again, what you do is you say, then I don't feel comfortable answering any other questions. You're going to go to jail. We've talked about what that process is like. If you want to go back, it's in episode 2. But we're now at the lawyer stage, and the lawyer should be asking these questions. So I'm describing for a lawyer why this matters. And the lawyer should then explain to the client why this matters. So now I'm telling you, Lacey, there's something called retrograde extrapolation, which because you're very smart, he's not going to be able to do. We also know as lawyers, we can use that in the trial and say, officer, there was a way that we could have known what Lacey was at the time of driving if you had asked one question. What was the time of your last drink? Now, I understand it may be because of training or you forgot, but we don't have that information because you didn't bother to ask. So you're asking this jury to guess. And that's not okay under the law that you were trained under, right, officer? You get the officer to tell the jury that they can't guess. I don't have to do it. The officer will do it for me, right? So now we know. We don't know the time of the last drink. Did he ask you, Lacey, to perform any standardized field sobriety tests?
He did.
Now, I don't have to tell the client what they are. The client knows what they are because she probably went through them. But it's important to inform the client that these tests don't work. First off, you have a battery of tests, which we'll go into in its own separate episode. But for this, you have an HGN test, horizontal gaze nystagmus. That's literally the most highly criticized tests of all of them, even though they will tell you it's the most accurate of tests. Then you have a walking test and a standing on one leg test. And I like to tell clients this, look, I know it doesn't work because do you ever walk heel to toe, one foot in front of the other?
No.
Do you ever stand on one leg? Is that your normal stance?
I'm horrible at yoga.
Then how on earth can a jury determine your normalcy by asking you to do something that is abnormal,
If
right?
they wanted me to sit, that would be a good,
Right.
accurate representation.
Can you stand? Can you walk? If you can't do those things that you normally could do, well, guess what? Probably means something's in, maybe the cocaine was a bad batch and you got some fentanyl. I don't know. But either way, keep in mind, I'm interviewing you, the client. I want to know what the facts are so I know what to advise you of what kind of case we're up against. So I'm writing this stuff down. And I say, I've got witnesses to show at 5:30 she's sober. I've got a couple of witnesses that will probably testify, because I'll ask you this, Lacey, would your friends be willing to testify that you were fine to drive when you left? Usually the answer is yes.
Yes.
So now I've got 2 other witnesses that are going to say, sober, fine to drive. We've had 3 glasses of wine in the past, even though we know it's 5, it's really 3. That's what they'll testify to. Everybody kind of has this idea that you eliminate 1 drink per hour. So over a 3-hour period, you should be back down to 0 and have no problems driving. And let's face it, most people have a beverage, an alcoholic beverage, when they go out to dinner or on a date. And everybody thinks it's okay to drive after that. They just don't think it's okay to drive if you're intoxicated. And a lot of the time, what I will do is I will explain to a jury that what does intoxication mean? Now, there's 3 different legal definitions of not normal mentally or not normal physically or above a 0.08. That really doesn't help a jury understand. So I say, you know what intoxicated means? If you look up the definition in a Webster's dictionary, you know what it shows?
What?
Drunk. You know what drunk means? If you look up drunk in a dictionary,
What?
it says intoxicated, right? They're synonyms. That's what they mean. That's what we're trying to prevent. We're not trying to prevent impaired driving of the slightest impairment. That's what the prosecutors will try and tell them, but that's not what it is. So I tell you, the jury, if you're not seeing a drunk person, that person ain't drunk. Because let's face it, we've all seen a drunk person.
Mm-hmm.
Now, if we want to talk about levels of impairment, that's different. That's not the law. But they're going to come back to, well, it's all about establishing what's normal and what's not normal. So it's not normal mentally or not normal physically or above a 0.08 at the time of driving. All right? Because we as a society have somehow determined that 0.08 is that level. I will tell you it used to be 0.10, and before that it was 0.12. So this is just an arbitrary number that we as a society go, well, we have more evidence that alcohol causes problems with driving, so we're going to reduce this. There's even talk about it going to 0.05, which essentially would mean you can't even have a drink and then drive. But I always tell the jury, if that's the case, then we just need to say that's the law. Otherwise, you can drink and drive. You just can't drink while intoxicated or drive while intoxicated. All right. So getting back to the hypothetical, we've gotten this information about witnesses. We've gotten the information about time of drinks. We've gotten the information about last known drink, which the officer does not know. And then he's asked you to do a field sobriety test. I will ask this question, obviously, because she has told me this. Did the officer ever ask if you had taken any other illegal substance? Most of the time, the answer is no, because if the officer suspects another substance, he will ask.
No, he didn't ask if I had taken anything else.
And there we go. We get to the point where I tell the client, well, what the government doesn't know won't hurt them, and we're not going to tell them. All right. That's where you, the attorney, do not have to give this information to the state. You are to keep it for yourself. In fact, it would be unethical for you to tell the state that.
Okay, so question. If, according to this hypothetical, I said I had cocaine, I've still got the cocaine somewhere. Let's say it's in my car.
Well, hopefully you used it.
I can't. Well, you're right. I was going to the drug dealer. I'm getting
So
okay, but
you're
what if?
out.
What
That's
if
why
I
you're
had,
going to the dealer.
What
but-
if I had drugs in my car though? Would they find it if my car was impounded? Are they going to go through my car?
There,
and then
there's
that's
something
another
called
charge?
an inventory search, and yes, that would be a separate charge. It would be a felony charge in that instance, and we would deal with that at the same time. In fact, many of my DWIs have a drug component to them. Either it's marijuana, or it's meth, or it's cocaine, or whatever. You know, hopefully it's not PCP, but we've had those too. All of these different drugs, most of the time, are not used in conjunction with the alcohol, but they're just like in the car. By the way, people, I don't know why everybody decides to smoke marijuana in their car like this is somehow the greatest idea. I think it comes from they don't want their parents to find out, and they did it in high school. But once you do that, your car smells like marijuana forever. You can't get that smell out. And then the officer walks up and he goes, I smell marijuana. And then all of a sudden you're on the curb and he's searching your car and he goes, oh, I found a roach from 1972. You're going to jail, right? Let's be smart about this. If you get a car and you smoke in it for whatever reason, you better get a good detail job. Get that smell out. Have air fresheners all over the place until you can't smell it because your nose is dead to it, right? It reeks. I don't care what people say. Marijuana reeks, and not like a good reek. I'm not saying the effects aren't fun, but the smell is atrocious, and everybody can smell it. It is distinct. And even though we have legal hemp now, you still give the officer the right to search. So that's my little sidetrack tangent going on that. We're going to assume the officer doesn't smell the marijuana in your car in this example. But so he's got you to do the field sobriety test. Now, most people do them. Did you do them, Lacey?
I did it, and I didn't do it well, according to them.
Right. Now, you know you didn't do it well because they arrested you. A lot of the people say, hey, I did it great. You know, I'm a great balancing act. They don't realize you can fail the test before the test begins. It's a stupid test. It doesn't work. There's studies on top of studies that show this is not a good gauge for intoxication. But guess what? Until they come up with something better, this is what we got. So the lawyer has to be able to explain to the jury essentially that. It's not a good measuring stick, but this is what we have. This is what we're dealing with. So anyway, you've done the field sobriety test, and then he placed you under arrest, right?
Yes.
Then after that, he asked you to do a blood test, probably. Did you consent to a blood test?
No, I did not.
Okay, so because you did not consent to a blood test, I inform my clients of this, and lawyers, you need to do this. Lacey, they probably took your license, and they have the ability to do that. They confiscated your license. Go get a new one, okay? Nothing is stopping you from going and getting a new license because you need an ID, and they're going to confiscate it, and they're not going to give it back. So just go to the DMV, get a new license. They'll send you one. Either you can do an address change or whatever the case may be. If you have to sit in the line, sit in the line, but it's important for you to have an ID. Lawyers, if you tell a client that, it shows that you know the process, right? So I'm explaining to you the process. Then I move into, hey, you're going to need what's known as an ALR hearing. An ALR hearing, because you refused, Lacey, has to be requested within 15 days or you lose the right to have it, and your license will be suspended for a period of 6 months. Now, lawyers, you need to know ALRs. We're going to do it a whole episode. In fact, that'll probably be episode 4, ALRs. But an ALR is something that can be a 90-day suspension if you consented and you provided something over the legal limit. It can be 180 days, so 6 months, in the event that you provided a specimen or did not provide a specimen in this case, and you have a license suspension because they can prove up the 2 things that they need, which are probable cause to arrest and reasonable suspicion to detain. And if you have a previous DWI, they can suspend your license for a period of 2 years. All of these things, these license suspensions, I can keep you driving. So I inform you, the client, Lacey, don't worry about them. We do them so that we get information that we can then use to win your criminal case. It is important to get that information. So in the ALR, if the officer doesn't show up, we win. If he does show up, we get good information that we're going to use to try and win your case. So both outcomes, very good, acceptable outcomes, right? Even if you get a license suspension, we can keep you driving with an occupational license. So there's really no harm here. It's all good. So lawyers do ALRs. And if you, as the client, have a lawyer that doesn't do ALRs, get out. Go find a new one. Even if he's your current lawyer, because that ALR matters. And if he doesn't know that, then he doesn't know how to defend you later on. So I inform you now about the ALR process. Hopefully you came to me within those 15 days. We're going to assume in this hypothetical that you did. So we send in a request. It's a simple form, 1-page form you send into Texas DPS saying who the person is, their license. You can do this for out-of-state licenses. Even though Texas cannot suspend an out-of-state license, all they can do is send the notice of suspension to that state asking for reciprocity that they suspend your license. The important thing to know is that you can do the ALR hearing. So the lawyer needs to know that and inform you, the client, we can do this. If it's a Florida license, no problem, right? We do that so that we can get that information because the ALR is about gathering information that we can use to win your case. And I inform you of this. All right. So after we're done talking about ALRs, right? Now we're going to talk about specifics and expectations. So Lacey, based upon what you told me, what I want to do is use the ALR to see if they can prove why they detained you is appropriate. So Lacey, you told me that they stopped you for swerving, right?
Yes.
Now, did you know that swerving is not against the law?
I did not.
So the Court of Criminal Appeals, highest court in Texas, and this is why the lawyer needs to show you, the citizen, his knowledge. Then the citizen, ladies and gentlemen, knows that their lawyer knows what he's talking about. Lacey, there's a case from the Court of Criminal Appeals that if the lawyer kept up with, shows that they said driving is the art of controlled swerving. Literally, all you're doing is controlling your car from swerving. You're trying to keep it straight because if you let it go, it's going to swerve. So guess what? They're right. It's amazing that they said that, but they're right. Normally, that goes against the defense. But in this particular instance, what I would do in the ALR is tell you, here's what we're going to do. In the ALR, I'm going to ask the officer, how many times did you swerve? And how far over the line did you go? Because if you went more than a car or half a car length, you now have to use a blinker, which is a different offense. But guess what? Most of the people don't understand this. An officer can't come back later and say, hey, I actually stopped her for failing to signal. Because let's imagine this scenario. In the ALR, Lacey, I get the officer to admit he only stopped you for swerving, because I'm a smart lawyer and I'm going to say, is the only thing that you detained Miss G for is swerving. That's the traffic offense that you saw, correct? Correct. It was not for any other offense, correct? Correct. Now I have established that even if you went more than half a car length, And even if the law requires you to have a blinker, and objectively, anybody could have seen that. If the officer didn't see it, you cannot then come up with, there's a case called Duran, another reason to pull them over after the fact. You had to have observed it at the time. In other words, once you got booted out because you did something wrong, you don't get to make something else up.
Mm-hmm.
So we're going to lock him into that testimony. That's why the ALR is so important, right? And then what's really, really good about the ALR is that I go, and at that point, you didn't suspect alcohol. Now, he might say, no, at that point, I did suspect alcohol. Okay, run with that. And he said, lawyers, you should ask these questions. Well, if you suspected alcohol, do you know what confirmation bias is? He'll either say yes or no. You explain it to him if he doesn't know, or she doesn't know. And then you say, well, slurred speech. Did you observe that? Yes. Did you ask if there was at any other time that you had heard them, or is this their normal speech? Whatever the case may be, did you ask any questions to determine that the speech, slurred speech that you heard, was due to intoxication? Usually the answer is no. Well, now we know that you could have asked one question to clear that up and you didn't. And we go down that road. How about odor of an alcoholic beverage? We go down this road because first, we want to win the case through what's known as a motion to suppress. The motion to suppress is saying the officer did not have the right to detain you, which is the swerving aspect.
Mm-hmm.
Then we look at the probable cause. We want to determine, does the officer have enough information to even indicate the second lowest burden of proof of this country, which is an opinion that you're intoxicated? If he does, he has the right to arrest you. But keep in mind, we've gotten this awesome information now that we are then going to use in the trial. Because what do we know? We know that whatever your BAC score is, they can't do retrograde extrapolation. That means that I've got a witness that's going to say that you had 3 drinks over 2 hours that would make you not intoxicated. A normal person would not be intoxicated for that. And I don't care what that score is. I'm going to find something wrong with that score. Unless you are obviously drunk, you should not be considered to be intoxicated based on your words and actions. Even if the driving was bad, even if the swerving was bad. What I want to establish is that because you don't know what they are at the time of driving, then you cannot say that this score matters, because we as a jury are not supposed to guess at what the score might have been. So we eliminate the 0.08. Now it's just, are you normal mentally or physically? And we know that these are not good tests. So if we know that they're not good tests, we get the officer to admit to that in the ALR, and then you win. So these are the ways in which you describe it. But when we're taking the meeting, Lacey, I want to, as the lawyer, inform you about the ALR that shows that I know what I'm doing, inform you about the process so that you know I know what happens, worst case, best case scenario, and then show you throughout my discussions of the process and the ALR that I know the law and I am competent, and that you feel confident that I am the right lawyer for you because I have demonstrated my capabilities, not by saying that I'm great, but by showing you how I would go about winning the case. Now I'm setting the expectation. So my expectation, Lacey, is that you will have a defense, and then the choice will come when we review the evidence. And we always review it together. A good lawyer reviews the evidence with his client so that the client knows what they're facing. If you don't, you are missing an opportunity for good communication and dialogue between you, the client, and the lawyer, so that you have an expectation of what you are fighting, and I can give you a good expectation of your chances of winning.
Okay.
All right? But as from the lawyer perspective, I'm demonstrating that I know what I'm talking about. I've given you the process. Now, we haven't actually talked about the process yet from the lawyer's perspective. So let me give you that, what I would tell every client. All right, now that you've been charged, Lacey, with the DWI, the ALR is going to go on. That takes about 6 months to occur. Now, while that's occurring, your criminal case will progress at the same time, usually the same rate. So you're going to have usually about, at least in the DFW area, 6 months of pre-trial settings, which the state has filed what's called an information charging you with the DWI, whether that be a DWI Class A, which means you were 0.15 or above at the time of testing, or this is your second DWI, or Class B, you were below a 0.15. And this is not a second offense, it's a first offense. Interestingly, you can be charged with 2 Class Bs. Let's say you have a Class B, this happens to me all the time, where you have a DWI pending, and then they go out and get another DWI. They can both be DWI first offenses because you have not been convicted until a plea or a trial of the first one. Make sense?
That makes sense. I don't know. I don't know that I would be pending one and getting another. That seems that
you wouldn't want that,
lot.
but it happens all the time.
Yeah.
But you as the lawyer need to explain this to the client so that they know, okay, so right now I would anticipate, based on the facts that you're telling me, is that you would be below a 0.15. Even with 5 glasses of wine over a 3-hour period, it's probably another 2 hours before you get blood tested, because they're going to get a warrant to search your blood if you refuse. And that's okay, as long as they go through that process, because in the warrant, they have to put why they're getting a warrant. Specificity matters. We can get cases thrown out because they didn't do the warrant properly. We do it all the time. So I anticipate that you would be below a 0.15 at the time of testing. And so you would be charged with a Class B misdemeanor, Lacey. So that's what we're going to anticipate. We're going to set that expectation. If you're charged with a Class A, it doesn't change anything as far as the timing. So it's probably going to be 6 months. We're going to get the discovery relatively quickly. We're going to do the ALR, and then I'm going to bring you back, and we're going to look at that video, audio, whatever evidence it is together. And then we will decide what the best strategy is, whether that be a motion to suppress, saying that they didn't have a right to detain you, or a motion to suppress saying they didn't have a right to arrest you, or simply a trial saying, hey, we don't believe that you're guilty beyond a reasonable doubt. Because remember, beyond a reasonable doubt is not the same thing as innocent. We're not trying to prove innocence in a criminal trial. We're trying to show that the evidence the state has produced is not to the level of beyond a reasonable doubt. And then, just so you know what a beyond a reasonable doubt is, the burdens of proof are reasonable suspicion to pull you over for a traffic offense. Probable cause, that's what you need for arrest. Second lowest burden, it's just an opinion. Then we have preponderance of the evidence. That's who do you believe more? Tip the scales. Even if it's an ounce, which side do you believe more? Then there's clear and convincing evidence. Then there's reasonable doubt. Then there's beyond a reasonable doubt. So we are literally way over here and to arrest right down here.
Mm-hmm.
So how do you fill in the gap, right? The question is, can they fill in the gap? I never question the officer on his opinion. I get that you have an opinion. I appreciate that you have a job. And it's an impossible situation, officer, because here you are with insufficient information to know, but you're asked to make a judgment call. That's what you did in this case. You're not saying that they're guilty beyond a reasonable doubt. You're saying at the time of arrest, I had to make a judgment call based on the totality of the circumstances I formed an opinion. And I say, and opinions are like what? Everybody's got one.
Mm-hmm.
Right? My dad used to say that. Then the jury will start laughing, and then we can move on. Because we all know it's just an opinion.
Can you curse in a courtroom?
I never advise cursing in a courtroom.
Do you say butthole? Because that's also funny.
Don't say butthole. What I say is
say it the way you did it.
I do it by
Okay.
like, officer, opinions are like a certain appendage my dad said. Everybody's got one. You agree with that? He's like, yeah.
Because if I saw someone cursing in a courtroom, I'd be like, man, that's cool. I didn't know you could do that.
You can do that if it's what a particular witness said, but I don't advise doing it. I'm saying, the greatest movie about lawyers that has ever been made, and I know To Kill a Mockingbird is the big deal, but the greatest movie to ever be made, or 12 Angry Men, is not those. Can you guess?
I have no idea.
I'm going to give you a hint. It's a Joe Pesci film.
I was just thinking Devil's Advocate, but I don't think that's...
No, it's My Cousin Vinny.
Oh, okay.
So in My Cousin Vinny, there's a scene where he's in opening statements, and the lawyer gets up for the state and does this real eloquent, is from Alabama, does the whole accent, eloquent opening statement to the jury. And Joe Pesci is this guy from New York that really hasn't passed the bar exam and is dressed in a leather jacket. And he gets up and he says, everything that guy said is bullshit. Right? I would love to be able to do that, but you'd be held in contempt of court and judge kick you out of the courtroom. And I don't advise cussing, but you can use it in certain situations to illustrate what a particular witness said or didn't say. Either way, what I will tell you is this: humor to get the officer to agree to things is a good thing. Getting the jury laughing is a good thing. It's a serious situation. They have to like you, the lawyer. If you, as the citizen, by the way, when you're hiring, like we discussed in episode 2, don't like your lawyer, the jury isn't going to like him either. If he doesn't communicate well with you, he's not going to communicate well with the jury. But if you establish that rapport and he can carry on a conversation and he lets you know, this is how I am in front of the jury, there's no change here. That's what you're going to get. And that's what you want.
Because it doesn't matter if they like me because I'm not the one up talking.
Usually you'll never talk in a DWI. Unless I need you, I won't let you, because nothing good can come of it. If I put you on the stand and they say, Lacey, this is the government cross-examining you. How many glasses of wine did you have?
4.
4? It was 3 in the video.
I mean 3. I had 3.
Oh, so it's really 4, isn't it?
No, I forgot.
You really meant?
I have 3.
Yeah. Did they give you a normal pour?
Yes.
Are you sure about
Below
that?
normal.
We went and took a picture of the pour. Do you want to rephrase?
I don't work in a restaurant.
Sure. But you don't think that sometimes they give you a little bit more?
I always imagined they shortchanged me.
Oh, really? So you think when you go to a wine, what wine enter sponsorship here?
Yeah, I figured, I pour a lot more whenever I'm at home.
Let me ask you this. Do you know what a normal glass of wine is?
Full. Yes.
Then we're going to go with, you got way more than the standard pour, because a glass of wine typically is a certain number of ounces, right?
I'm going to guess 8.
6.
6.
Yeah. And if you get 6 ounces of wine, right, that's actually not that much. It's barely in a big glass. It's barely into the quarter section of the big glass. If you get a half a glass of a big glass, you're getting double, right? So a good way to think about it is, if you can't describe whether or not you had a normal glass of wine times what you guys talked about, why you can articulate why you were not intoxicated, probably not a good idea to put that client on the stand. However, I have had clients where I tell them, you'd be wonderful on the stand and I'd love to put you on the stand. I had one that had a learning disability. So I knew he was going to be terrible, but part of my defense was he was not intoxicated. He had a learning disability. And you know what? It worked.
He's not intoxicated. He's just like that.
Well, and unfortunately, that happened to be true. Now, we were able to establish some other things, that the blood test wasn't entirely accurate, but you throw that on as the icing on the cake because you go last. So the attorney needs to explain to you, the citizen, hey, you go last if I decide to use you as evidence. Our witnesses go last. So we're going to know what the evidence is before they talk. I like to use other people, not you. So I would use coworkers to say, no drinks before 5:30. Then I would use your friends to say, we had 3 drinks. We know her well. She was fine to drive. And then I'd show them the video of her walking and talking. I was like, is that what she's like normally? And they're going to be like, yeah. Well, they're the people that know you best, not the officer. So why do we have any reason to disagree with them? And they're like, well, this is an officer and he's trained. Is he though? Because we'll get into this. Standardized field sobriety testing is a 3-day course that is 24 hours. That's it. Did you learn anything in college if you had 3 days on a subject? No, you moved on to the next subject. And they have 9 months of training. So out of 9 months of training, you had 3 days dedicated to something that you spend most of your life doing. All right. So all of this to say is, when I am meeting with you, lawyers, pay attention. I set the expectation by getting the facts. And I get the facts and I set the expectation by showing them that I am knowledgeable about how I would use those facts to win their case. If you want them to be a client and if you want to make them feel good about their decision, then you need to communicate to them not only that you know about what you're doing, but you can use the facts of their particular situation to win their case. Now, I have a lot of clients that come in and they say, hey, we've seen you win this case and that case, so you should be able to win ours, right? You have to be able to explain to them every case is different. I can't win your case just based on the other case because the other case had different facts. Perfect example. We had a guy who about 5 years ago, he flipped his car into a house. He literally was so drunk, he hit a fire hydrant at a high rate of speed, flipped his car end over end, went through the roof, and was in the living room of a house.
That's so scary.
He was a 0.24, which is triple the legal limit at the time of testing, which was 7 hours after the accident. Police, fire everywhere, right? There was no way. This guy admitted to being drunk at the hospital. He came in and said, there's no way to win. And I said, well, hang on, let's take a look at the facts first. So we do the ALR. And in the ALR, what do we ask? Officer, what made you believe that because this person's already in the house, like they're in the car upside down. What made you believe that this person needed to be arrested? Did you smell the odor? Did you have slurred speech? Wasn't he unconscious? And the officer admitted he was unconscious, so I had no ability to talk to him. So I said, so you really had no idea whether or not he had the odor of an alcoholic beverage because he's unconscious. You didn't do mouth to mouth. She goes, no, the paramedics were involved. I was like, so we walked through the process, and it turns out paramedics were there first. Obviously, the officer has a right to be there. The officer does have a right to investigate, but they would be investigating the crash. That's what they should be investigating. Well, after the officer investigated the crash, he already had his identifying information because they had his wallet already. She had the car information. She had what happened because she could see the screech marks right before the fire hydrant. She could see how the car flipped. So she had all the information she needed to do her crash report. There was no real need to talk to the individual unless you were investigating something else. So we established that. There was no real need to go to the hospital and investigate unless there was something else you were trying to investigate. She goes, well, there was. What was it? I was investigating whether or not he was driving while intoxicated. And I said, great. Okay. So now you have a suspicion of driving while intoxicated, right? She goes, right. But you hadn't had a chance to interview him or talk to him at all at this point. She goes, correct. Now, at that point in time, you would agree with me that what you had is called reasonable suspicion. You had a suspicion based on facts, which is the car flipped over, even though you didn't smell alcohol, no seeing of a reason why that would happen this time of night, that type of thing. She goes, yeah. But you didn't have probable cause, right? Probable cause, you needed some more information to determine whether or not this person was in fact intoxicated. Otherwise, it's just a hunch. She goes, that's correct. I was like, but what did you do next before you went to the hospital? She goes, what do you mean? I was like, you filled out some paperwork. What was that? It's called DIC paperwork. So when you get arrested, ladies and gentlemen, for driving while intoxicated, you will get DIC paperwork, which indicates whether or not they gave you the statutory warning of, hey, these are the consequences of getting arrested for DWI. Do you want to consent to a blood draw or breath test, or do you want to refuse? That is a DIC form that they give you. They're required for you to read along with it so you know what it is that you're being charged with and what your options are for the license suspension. All going back to the license suspension. So I said, officer, you filled that out at this time. She goes, yes, I did. And the title of it says, you are under arrest for an offense, the driving while intoxicated offense. She goes, correct. I was like, but you didn't get to the hospital until an hour later. She goes, that is also correct. I was like, so he was arrested before you had a chance to do your investigation. She goes, and I was like, kind of cart before the horse, right? She had to say yes. And You were telling me honestly a minute ago, hey, I don't have enough information to arrest. That's why I'm investigating. She goes, that's right. I was like, so at the time you actually issued the arrest, you did not have enough information to do so. That's correct. We won. Mm-hmm. The entire case is thrown out on what's called a lack of probable cause. So it's a motion to suppress. We didn't even need a trial. The judge ruled that they didn't have enough probable cause because the officer admitted to that. And you win the case where a guy is 3 times the legal limit and parked inside somebody's living room. So no matter how bad the facts are, lawyers, you don't have to take away hope. That is the single greatest thing your client has. They have hope that somehow you, the attorney, can use your legal wizardry to win their case. You don't have to set unrealistic expectations, but you do need to give them hope because no case is unwinnable.
Which you'll give them hope whenever you're telling your client right there all about the expectations.
That's right. I'm going to tell them how I can use the facts of their case to try and win. And they're going to believe that I have that ability because I've shown my knowledge, and maybe give them an example like that of how there was seemingly no hope and then we won. So don't let your client leave there. They already feel bad enough about getting arrested. Normally, this is the first time they've ever done anything wrong in their entire life, including a speeding ticket. They're already mortified. Do not judge them. Do not make them feel bad. Make them feel like they are part of the family, which we will do at Lassiter Criminal Defense.
How do people get a hold of you, Mark Lassiter?
You can get a hold of us at 214-845-7007, and you'll see it at the bottom of your screen, www.lomtl.com. You can type Mark Lassiter into Google on the first 10 things that pop up, or you can email me at mark@lomtl.com.
Another great episode of Lassiter Law Podcast. Thank you so much, Mark Lassiter.
We'll see you guys next time.
ProPod Digital.